Good evening and welcome to the Teske Brief. I'm Judge Steven Teske, retired, and this series titled The Bar Card and the Breakdown of Justice, we examine one of the most important stories in American law and government today. It's this: what happens when the lawyers entrusted to enforce justice begin to fear the very system they serve? Now, across this series, we'll explore and have been exploring why experienced prosecutors are leaving the Department of Justice, how political pressure can distort legal judgment, why independent courts and state bars still matter, and what is lost when institutions ask for power but stop earning trust. Look, this is not a story about personalities alone. This is a story about professional duty, constitutional guardrails, and whether the rule of law can withstand the pressures placed upon it. Folks, this is episode 8, and it is titled The Courtroom Pushback. Now, before we begin, remember, titles are temporary, power is borrowed, integrity is tested when pressure arrives, and this is the Teske Brief. Welcome back. Now, one of the fastest ways to find out whether power respects limits is to watch how it reacts when a judge says, "Show me the evidence." Because you see, in healthy systems, that's normal. In unhealthy systems, that's apparently grounds for a nickname, a misconduct complaint against the judge, and 3 angry cable hits before lunch. Welcome to the Courtroom Pushback. You see, most institutional problems stay hidden until they hit a courtroom. Inside agencies, people can spin things, right? They can talk all they want, embellish, puff their chests. Meetings can be managed, emails can be massaged, weak decisions can be rebranded as strategy. But in court, oh, it's a whole different world, folks. Now the claims need proof. Now procedures matter. Now there's the thing called the rules of evidence. Now somebody neutral gets to ask questions no one wanted asked. That's why so many bigger institutional problems first become visible in front of a judge. Now, let's talk about judges for a moment, about their role. You see, judges do not run investigations. They do not decide who gets indicted. They're not supposed to manage the executive branch like a frustrated substitute teacher. I would often say on the bench, hey, I just sit up here just fat, dumb, and happy, waiting for the problem to come to me and try to help people navigate and resolve the issue. We don't investigate it. We don't ask it to come to court. We don't invite it. We're just there until it comes. You see, the judge's job is much narrower, and it's more important. They ask, do you have legal authority? Do you have factual support? Do you follow the rules? Do you have jurisdiction? Are you even supposed to be here? Are you in the right court? I mean, the questions go on. You see, folks, that's not activism. That's literally the assignment of a judge. And courts push back when something feels off. They have to. That's their job. That's why they wear a robe. Okay? I mean, they are in that third branch. And by the way, our founding fathers intended that third branch, the judicial branch, to be undemocratic. That's why they wear robes and look like a king, for goodness sakes. They're supposed to be undemocratic. They're supposed to be more authoritarian with rules. Because you see, sometimes the majority gets it wrong, and the majority passes laws that violate the Constitution. And you need that undemocratic branch where the people are appointed for life and therefore do not fear that they're going to lose their job because they ticked off the majority by saying, hey, you passed a law and it violates the Constitution. See, our founding fathers were pretty smart. Now, when the timeline is suspiciously rushed, when the evidence looks thin from a judge's perspective, when shortcuts appear, when the legal theory sounds like it was written 5 minutes before filing, well, when one person seems to be treated differently because they are useful, famous, inconvenient, or politically valuable, those are the moments when judges start kind of leaning forward. And when judges lean forward, folks, institutions that prefer autopilot, they get a bit nervous. Now, why do questions matter? Well, you see, sometimes the judge's questions matter more than the ruling. Why now? Where's the evidence? Why skip the normal procedure? Who else gets treated this way? Those questions force something rare in modern public life, and it's called, well, clarity. Because outside the court, people can repeat claims endlessly, all they want. Put it on Twitter, put it on Facebook, put it on LinkedIn, okay, Instagram. Anyway, inside the court, repetition is not evidence, folks. What is said out there is not evidence. And volume is not proof. You can say it all you want, as much as you want, okay? But when it gets into a courtroom, oh, you have a lot of restrictions because you have a lot of rules. And the purpose of the rules is to make sure only those things that can be said in court can be proven, that they're not hearsay. Anyway, now, here's where it gets uglier. When courts insist on evidence and process, the response is not always a legal argument. Sometimes it's intimidation. Judges who rule against executive priorities suddenly become rogue. We've heard that recently, right? We've heard the president call the judges rogue. We've even heard Pam Bondi, when she was the U.S. Attorney General, use the word rogue on judges. We have these rogue liberal judges, okay, or radical, or agitators, right? They become now common nomenclature in the executive branch in attacking judges when judges make decisions the executive branch doesn't like. This is a new day, folks. We're really not, I mean, we've been around for 250 years. This is the year we're celebrating the 250th birthday of the United States. And folks, this has never been like this before. And which is interesting because asking for evidence used to be called judging. Now, it's apparently a personality disorder for a judge to ask for competent evidence, demand competent evidence. We've seen misconduct complaints filed against judges, impeachment threats floated around about them, and public attacks designed to delegitimize judges before anyone reads the ruling. Folks, that's not rebuttal. That's pressure with a microphone. Take Chief Judge James Boasberg out of the Washington, D.C. Federal District. A misconduct complaint was publicly pushed against him. Serious accusations, a lot of big noise. Then a reviewing court asked for evidence. And you know what? Nothing. No factual support. Complaint dismissed. Which means that the judiciary had to spend time addressing a case that appears to have had less evidence than the rulings it was attacking. Folks, that's not oversight. That's weaponized nuisance. Now, there's another development occurring inside federal courtrooms that has received far less attention than the public attacks on judges. And frankly, it may be even more troubling. Because the issue is no longer simply whether judges agree with the Department of Justice. The issue has now become whether judges believe the Department of Justice. Now, as a former judge, let me explain why that distinction matters. You see, the justice system runs on trust, not blind trust, just earned trust. When a Department of Justice lawyer stands before a federal judge and makes a factual representation, there has long been an assumption that the lawyer is being candid with the court. Lawyers call it credibility. Judges call it candor. The legal system calls it the presumption of regularity. It is one of the reasons federal courts can function efficiently. Because if every statement by government counsel had to be independently verified before a judge could rely upon it, the entire system would grind to a halt. That trust account has been built over generations. And what we're now witnessing is judges openly warning that the account is running low. You take Judge Mary McElroy in Rhode Island, not a Biden appointee. In fact, she was a Trump appointee. In a recent case involving government efforts to obtain medical records, the Department of Justice lawyers represented that hospital counsel had stopped communicating with them. But emails showed something very different, that the hospital's lawyers had remained in contact. Judge McElroy reviewed the record and described the government's representations as, quote, misleading, if not utterly false. Then she delivered a sentence that should send chills through anyone who cares about the integrity of the Justice Department. She wrote that the Department of Justice had, quote, proven unworthy of this trust. Now, I want you to think about that. A federal judge said that the Department of Justice is unworthy of trust. That's not criticism. That is a warning flare. And it doesn't stop there. In Chicago, Judge April Perry reviewed allegations involving grand jury proceedings. She concluded that portions of the transcripts had been omitted and that the government appeared to be hiding rather than correcting mistakes. And what did she say? Well, she said, quote, mistakes happen, but as I tell my children, you own it. You admit to it, you apologize for it, and you move on. What you do not do is hide it. Imagine a federal judge having to speak to government lawyers the way a parent speaks to a child, caught with a hand in the cookie jar. Folks, that is not normal. Look, then we have Judge Melissa DuBose in Rhode Island. She was so concerned about a Department of Justice lawyer's lack of candor that she appointed outside counsel to investigate the conduct. She described the incident as a serious breakdown in the ethical codes. Not a misunderstanding, not a disagreement, a breakdown in the ethical codes. And perhaps most revealing was a federal judge in Tennessee reviewing testimony from a prosecutor who claimed he alone had decided to revive a controversial criminal case. Now, the judge later learned that senior Department of Justice officials in Washington had remained closely involved. His response? He referred to the prosecutor's account only to the extent that it is credible. You see, for non-lawyers, let me translate. That judicial language for, I'm not sure I believe you. That's what it really meant. I'm not sure I believe you. Judges almost never say things like that publicly, because once a judge begins questioning a lawyer's credibility, everything changes. Every future representation gets scrutinized more carefully. Every factual assertion receives more skepticism. Every filing gets a second look.
So the judges are saying some incredible things.
Ryan Goodman is a law professor at New York University who heads a nonpartisan law journal. His team has analyzed hundreds of suits filed against the administration, and he didn't imagine what judges were saying to the Trump Justice Department.
We found over 35 cases in which the judges have specifically said, what the government is providing me is false information. It might be intentionally false information, including false sworn declarations time and again.
In court records compiled by Goodman, Democratic and Republican-appointed judges are critical of the Trump Justice Department's work. Highly misleading, said one judge. A serious violation of the court's order, wrote another. And a third warned, trust that had been earned over generations has been lost in weeks. This isn't the way things normally proceed?
It's not. In fact, I would say for some of the cases that we're looking at, maybe that would happen once every 10 years.
Who gets hurt by this?
The one entity or person or institution that gets hurt the most is the Justice Department.
And here's why this matters. The judiciary can survive disagreement. Judges and lawyers disagree every day. The judiciary can survive criticism. The judiciary can survive appeals. What it struggles to survive is the erosion of trust between the bench and the lawyers appearing before it. Because once judges stop believing government lawyers, every case becomes harder. Every hearing becomes longer. Every representation requires verification. And eventually the system slows under the weight of its own suspicion. One former Department of Justice lawyer interviewed in connection with these developments put it perfectly. The longer this continues, he warned, the fewer good lawyers will want to stay. And over time, it becomes harder to do even routine cases if judges no longer trust you. That may be the most important point of all. The story is no longer simply that courts are pushing back. The story is why. Because judges are beginning to recognize that the issue before them is larger than any one case. The issue is whether the Department of Justice carries the credibility that generations of lawyers spent decades building. Trust takes years to earn, minutes to lose. And institutions sometimes spend decades trying to recover it. And let's be honest, folks, about something else. This isn't just rhetorical anymore. Judges have faced threats, security concerns, personal targeting. So when a judge still walks into court and says, no, the government still has to meet its burden, that is not activism. That is institutional courage. This tension is not a bug in the system. It is the system. The executive branch has speed, investigators, charging power, and urgency. Courts have independence, process, and the annoying habit of asking for receipts, for the evidence. You need both. Unchecked executive power becomes abuse. A judiciary that never questions power becomes decorative. Neither one is acceptable. Courts also teach the public an important lesson. Press releases are accusations. Cable segments are narratives. Social media is often just adrenaline with Wi-Fi. But court is where claims get tested. Opposing counsel responds. Records are created. Facts get separated from slogans. That's why some stories look very different after a hearing than they did after a press conference. So when you hear attacks on judges for doing ordinary judicial work, ask yourself, is the real complaint about bias or about being questioned? Because in a constitutional democracy, nobody gets immunity from questions. Not prosecutors, not agencies, not presidents, not anyone. Every time a court demands proof, it reminds the country of something simple. Authority is not enough. Power still has to earn its way. And folks, I'm Judge Steven Teske, retired, and this is the Teske Brief. Remember, when asking for evidence becomes controversial, the evidence may not be the real problem. Until the next episode, take care and be safe. Goodbye.